All right, hello everybody. I am sure people will start logging in the next few minutes, usually for the first 15, 20 minutes, or even actually in the last 20 minutes, people will start logging in. So let me just introduce myself. I am Nicole Canyon, and I am the San Francisco, Northern California chapter president, or sorry, chapter council president for FIABC, International Real Estate Federation. I also am the existing events, communications, marketing, and PR chairperson. And this is our final webinar on financial fundamentals, becoming FIABC's focus for this last week. I'm joined by Kent Tierney, who is a very accomplished attorney in the San Francisco Bay Area. His areas of expertise are in real estate law, probate, family law, and business law. I have actually had the pleasure of working with him on all four of these different branches of law. So I'm going to go ahead and let Kent kind of introduce himself, and then we'll get into the basics of probate. Because this is a smaller session, I feel like we have the ability to be more intimate with asking our questions. So unless it starts growing over 15 plus to 20, 30 people, I can say that if you want to unmute yourself to ask questions, you can. If it gets over 15 people, I will mute and ask that everybody ask questions via the chat, and then I'll pose them to Kent myself. So go ahead, Kent.
Hello. I think you said what our firm does. We do family law, we do real estate, we do estate planning. I represent a lot of businesses, a lot of small businesses, landlords, property owners, business owners. So I guess we're a family practice in that we cover everything that would be related to a family, marriage, divorce, death. They're all and acquisition of property. They're all kind of intertwined. I think today, Nicole, you wanted to talk about living trusts and the estate planning vehicles that can be used. You had sent me some general questions. I'm happy to go over the general questions if you want, or if you want to ask me them. And then we can, it doesn't look like I have one page of participants, so honestly, I can hear pretty well. I don't care if you open up after you ask me a few intro questions, if we open it up to the participants and let them ask.
Absolutely.
I'm fine with that.
That's kind of what I was thinking. I'll ask the first few to get the conversation going. And lucky for the people who are on the call today, because then they actually get a little bit more attention to their own personal questions with you. So perfect.
No problem.
If it starts to get crazy, then we'll, like I said, we'll scale it back. But let's go ahead and go with this format. I like that. So the first thing is, what would be the main reasons why anybody would need an estate plan? And I say anybody because a lot of people might disqualify themselves from needing one because they don't have millions of dollars or millions of dollars worth of assets.
Well, what I found recently, especially during this, I'm not going to call it a pandemic. I'll call it the shelter in place thing. Is a lot of people are questioning, future, what's going to happen, and then what is their legacy? What am I leaving? Who am I leaving it to? Most times when you think of a trust or any kind of estate planning, you think of if you have children and if you own property. That is, my ideal customer or my ideal client is that particular client. Although if you don't have children, but you have a family that you want to leave property to, that makes sense too. I'm having a lot of single people during this period that own things and want to make sure that they go to other family members. But I think the reason to do any kind of estate planning is so that you have some control over where things go, and that you don't leave your family or others with a complicated situation when you are no longer here. And I think the biggest issue is, I'm dead, I don't care. Whatever's going to happen happens. It's not, let them deal with it. If you have children and you do that, you're creating a situation where children or family are likely to fight. People will say, oh no, my family's different. When it comes to money, you don't know what people are going to do. You want to take those decisions away from those family members. It's ultimately your wishes at death. So whatever you put down, courts are very loath to change anybody's testamentary documents without some real significant proof. So I think, my normal customers, husband and wife, just had a kid, they own a home. They're concerned about what's going to happen in the future. And then I have people like me, and I'll admit it, I have a second, I'm married for a second time. I have 2 kids from my first marriage. My current wife, who I've been married to for 10 years, has a kid. And we didn't have a trust until maybe 2 years ago. Because of the blended family, it was very difficult trying to figure out who was going to get what, how we were going to divide it. But it's really hard for me to preach to clients that, hey, you need a trust. If you don't have a trust, you're stupid. And when I don't have one myself, so I do have one now. But I think it gives you control over what's going to happen. And there's a lot of bad things that could happen if you don't have one. And the people who are going to make out great when you don't have one are lawyers and the court system and everybody around that system, and the process to probate, say, a will, if that's all you have. I have nightmare stories that I'm dealing with a very famous Hall of Fame pitcher whose mother died 3 years ago, and she left a will and did not have much in assets other than a house. The house was sold and distributed between 3 family members. And 3 years later, we are still trying to get the court to actually finalize the estate. There's no reason that it should still be open, except that the court system likes to hang on to things and drag them out. So if you have a trust and an overall estate plan, you can avoid having to go to court. You can avoid inheritance taxes. You can avoid all kinds of headaches. So I went a little long there, so I'll let you ask another question.
Well, actually, expanding on what you were just speaking about, what's the difference between a will and a trust and a revocable trust? And what are the pluses and minuses?
Okay. When I do a trust, I include a will inside the trust, so that a will really is a way for you to pass property to someone specifically, but it's in the vehicle of a trust. If you just have a will and you die with a will, you have to probate that will. So you have to take it to the court, you have to register it with the court, then you have to send out notices to anybody who might be interested in that will. A trust, you can encompass the will inside of the trust, and the trust is a vehicle that allows you to not have to go to court. You name a trustee, the trustee administers the trust, and there is no court involvement. There are documents that need to be filed, and the trustee has duties that the trustee has to follow, but there are under a certain amount of money, there are no inheritance taxes. There's no court involvement. In fact, if you do a trust and you do it correctly, the only thing that you're doing is signing documents and moving things around, but you're not asking the court for permission to do anything, because the trustee, the administrator of the trust, has all the power. And in a trust document, when we write them, we define what powers that trustee has. And to your second question, the difference between they call it an inter vivos trust or living trust, and a revocable or irrevocable trust. So living trusts are always revocable unless you deem them to be irrevocable. So example, my wife and I have a trust. We are the trustees of our trust while we are alive. We have the right to amend, change, modify, revoke, do whatever we want with that trust, because we own the property. It's almost like, Nicole, it's like an S corp LLC pass-through entity, right? Mm-hmm. If we make it irrevocable, we are no longer the owners or the trustees of our own trust. We've essentially given control of that property over to someone else, and then I can't revoke it. I don't prepare irrevocable trusts. I think they're not smart. They're complicated. They are a tool that can be used to avoid liability, which lots of people think are under the false belief that if all my stuff's in a trust, it's protected. You asked that question. We can get to that in a minute, but it's not, because it's a pass-through entity. But the living trust is always changeable, always modifiable, unless you make it irrevocable. And I would say there's very, very few circumstances that I would ever advise a client to make it irrevocable.
Okay. So when in life do you feel like people should start an estate plan?
Well, if you're a planner, you start right away. If you're single and you have, no assets, and you have no children, there's no, it's really up to you. I think that if you're married and you have a child and you own property, you're doing a disservice to your child if you don't have a trust. Because let's say the child's 2 years old and something happens to mom and dad, you want to make sure that you've named a guardian. You want to make sure that you've named, set up a way that if your property is maintained by the trustee, that money is going to an account that is protecting the minor. Because otherwise you die, families, tend to get greedy. And I've seen it, people say, oh, that's not my family. That's that weird family I see on TV. And I'm going to tell you right now, if every single family will run into something, some sort of greed or demand, or, oh, dad said he was going to give me those guns, or those, papers belong to so-and-so. And it's just, when the matriarch or patriarch of a family dies, the respect that goes with them when they die often follows them to the grave, and people act differently.
I can vouch for that in both sides of my family.
I can personally myself. So
and there was my family that I swear was the Brady Bunch, that we were never going to fight, and that is the family that broke down the quickest. So I do have to say that is very true.
And that's the people who come to me and they have multiple kids and they say, all right, we're gonna, and they don't have to be I have 3 kids, and I'm going to name all 3 of them as co-trustees of my trust. So when I'm dead, all 3 of them can get together and no. Big mistake naming 2 co-trustees, because getting the 2, I've had families where 2 brothers who are best friends for their entire lives are now co-trustees, and they're suing each other, or they're fighting over, the Indian art that mom, had in the garage that so-and-so's wife stole when they weren't looking. And just name the oldest, or name the child you trust the most. You're dead. You don't have to explain why you named what kid what as the trustee. My youngest is my trustee. He's 20. And I have a 25-year-old and a 23-year-old. And at some point, they're all going to sit around and go, hey, why is the youngest the trustee? Because he's the smartest and he's the least crazy of my 3 kids.
That's why I'm the trustee of my parents too. Oh, that's funny. Okay.
Now,
so
there's other ways that you can pass property, Nicole. And I know that was one of your questions on your list.
Mm-hmm.
Was if you don't need a trust if you have certain types of deeds. So if you have something in joint tenancy with somebody, you don't need a trust to pass property. If you have community right of survivorship, where when someone dies, the other person gets the entire share, you don't need a trust. There is this new invention in 2016, this transfer on death deeds. that you can essentially, once you die, transfer it to someone else. There's limited, and I don't know if you've heard of those, the TOD. They were started in 2016. There's a weird sunset clause with that, in that the law sunsets at the end of this year, meaning in January of 2021, they're no longer going to be allowed, but that might change depending on the legislature, except I think the legislature has something bigger to deal with right now. But there's pros and cons to doing transfer on death. It's limited to a single family home or a condo. It's limited to a residence on 40 acres or less, and it's also limited to units that have less than 4 residential dwelling units. But I don't do them. I think that there's too many negatives to positives. But if last minute it's something that you need done and you haven't done an estate plan and you want to make sure that it transfers to someone on death and you are in a hurry, then you can do these. You can also revoke them as easy as you write them. So I'm going on a trip. I'm going to Europe. Back when you used to be able to fly a plane across the world. And I want to make sure if something happens to me, I don't have time to execute a trust right now. I don't really like my will, but I want to make sure Nicole gets everything. So I'm going to do a transfer, on death deed, and I'm going to name Nicole. And then when I get back, if I survive my trip to Italy, where I was last year, remarkably, then I can revoke the transfer to you, and I can record something that says I revoke it, or I can then turn around and record an additional document or withdraw my transfer on death. It's there to use. I think since it started in 2016, I think I've written 3 total compared to 250 living trusts. So I don't think it's the preferred vehicle, but it's an option.
Okay. Just a couple more questions. Then I actually have one client specific one, and then I'll open it up to everybody. When or how often should you update your estate plan once you have one in play?
Well, look, I have trusts from a family that owns about half of downtown Pleasanton. If you drove around and pointed at a building and said, "Oh, they own that," they've changed their trust 3 times in 40 years. The law changes a lot, but I think the intent of trust documents is what the court looks at. So as long as you have the right structure and it's very clear in interpreting it, you don't have to update it unless you're making major changes. Now, the thing with a trust, which is it's just like a will, there's a thing called a codicil, which just means little will, that you can change your trust with an amendment, which is a 1-2-page document, and every spot in the trust that references a specific section. Like I just did an amendment last week. A client of mine got remarried and wanted to name, obviously add his new wife, and then wanted to grant a life estate to one of his grandkids or something. So we just amended the parts of the trust that made changes, and you attach it to the back of the binder of the trust, and there you go. It's not and look, and I also have a client but she just died about a year ago. For 3 or 4 years she was in my office about every 3 or 4 months. This grandchild, I just learned that she changed the trust. Week later, come back in, and it was like up and down, up and down, up and down. Finally, we just stopped meeting with her as much. And in the end, she ended up withdrawing almost all of the negative things about her family. And when she died, it was fairly clean, and we met with the family and went over what needed to be done. And they were patient with her because she had a temper. So I honestly, I've got some that are in my office on a shelf that we haven't touched in 5 or 6 years. They'll call us and say, "Hey, can you just take a look at it and make sure we actually did something. Kids will grow up and be over 18. Doesn't mean you have to change the trust to comment, oh, now they're over 18 and we don't need a guardian. That automatically is kind of, falls off the trust and is not applicable. So.
Okay. So my specific question, I have a client or clients who purchased a house together. They're not married, but they've been together 30 years. The wife.
There is no common law marriage in California.
I do know that. So knowing that, the wife is the one who put about $300,000 down on the house. The supposed husband didn't put any
supposed husband
didn't put any cash down, but they're both paying the mortgage. So she wants it. Then they have a joint tenancy. That's the way they're holding title currently. How would it be best for them to work this out, possible trust or individual trusts, so that if she survives, his portion goes to her, but if he survives, her portion goes to her, more than her portion goes to her children?
Okay. They're not married.
Not married.
And they're not planning to get married.
Never.
Then they don't need a joint trust because they're not married.
Mm-hmm.
They need one individually to handle each of their estates. It probably makes sense if they own the property in joint tenancy that they have some sort of property agreement between them. I'm assuming that the party that put the $300,000 down to buy the house wants the first $300,000 out of the sale, or upon death, they want the first $300,000 to go back to their heirs.
Exactly. So
in order to do that, you kind of need an agreement between owners, because if they're owning in a joint tenancy now, one has the right to partition, which means that depending on which one's your client, if your client is the one that put the $300,000 down and wants protection, she should get an agreement, not necessarily a trust, but an agreement now. Because if they own it as joint tenants, the one who didn't put the $300,000 down now has the right to, if something happens, say, I want my ownership rights out of that property. I want partition. They could force it to be sold, and then you're litigating over where that $300,000 came from. You can just put that into an ownership agreement and say, I acknowledge, and it's simple. I acknowledge that you put $300,000 down on this house, and that you are entitled to the first $300,000 out of this investment, should it sell or should one of us pass. Okay. They can't have a married trust since they aren't married.
Yeah, I figured that. I knew that they're going to both have to get individual trusts.
But you can have them be dependent on each other, and we do those a lot. But it's easier if you have a property ownership agreement for non-married couple. And once they're both on the deed, then there's arguments about the intent when you put them on the deed, and but it can be solved. It's better to solve it now than to die and leave two families fighting over a piece of property, because that's usually what happens.
Absolutely. Well, and then there's children that are a part of the person who didn't have money put down, that they don't want anything to have to do with the estate because they're not good people and all these things. So yeah, that makes sense. Okay. So as of right now, I'm going to open it up to questions because we have such a small group. You can go ahead and unmute yourself and ask a question of Kent if you have any specific questions or trust.
And I would say, Nicole, one of the things you asked me at the beginning is why you need a trust or a will. And if you don't have one and you die, your estate is then intestate, and then it falls in the line of succession under California law as to what is succession, is to who gets what. And it's fairly simple, but it can be complicated. But if you have a child, then obviously it flows down to your child. But you're creating, I'm not going to cuss on a Zoom call because you're recording me. You're creating a, blank storm, blank show if you leave them with nothing. And then they're going to go have to hire Cuss away. No. If she wasn't recording me, absolutely, but not if she's recording. You're just leaving a nightmare for your kids to deal with. And you're talking about, it's already hard enough to deal with someone's death, and no one likes talking about this. This is probably the hardest part about the living trust probate part of our practice, is that we talk about buying businesses and merging and selling property all the time. But as soon as I raise, hey, do you guys, do you have a trust? You guys should have a trust. They're not super expensive. They're a necessity. There are things you have to talk about in them. What are you going to do with your body? Are you going to donate, tissue? Where do you want to be buried? And those are things that aren't pleasant to talk about, but they should be done, because if they're not, then your kid is going to basically spend a good part of the money that you left them, or the property that you left them, having to hire somebody to clean it up. And that clearly is not the intent of anybody when they die, is to create a billable event for a group of lawyers and a court system. Because then that's taking the money right out of the pocket of your heirs.
Well, and even to speak to the emotional aspect of it, because I've been through this twice with both of my families, with both my grandparents passing, you're already dealing with the loss and the emotionality of the loss, but then having to make decisions on what you think that they would have wanted, or having everybody be able to agree, even on whether or not to pull a plug, whether it's okay to cremate, to bury. Like, those are all, everybody has their own opinions, and if they're not put in writing by the person who has passed, it makes it so much harder on the family, and emotionally even more taxing.
I'll give you a good quick story. My father-in-law, my wife's dad, died 2 years ago in February, and he died in a way that it's called, I think, palliative care, where they basically let him decide. He had chronic heart failure, 90-something% blockage of all of his arteries, and severe diabetes. He was gonna die. He could either go home and die alone, or he could die in the hospital under their care. And he was telling us, before, he had no will, he had no assets, he had nothing to leave, like literally one car. But he was telling us, before he was hopped up on morphine, I want to be buried here. And he was very clear. And then he lived through this palliative care thing for about a week, and he told every single person in the family something different. I want to be cremated and my ass spread in Monterey. I want to be shot out of a cannon at Appomattox, from my relatives who were in the Civil War. I want to be thrown off of an airplane. I mean, by the time it was over, every single family member had a different story as to what he wanted done. They cremated him and then gave each, there were 4 brothers and sisters total. They gave them each a portion of his ashes and said, hey, do what you think is best with his ashes. Because he clearly wanted to be cremated. But it's not fair for someone like you, Nicole, to come along and say, all right, well, I know what grandma wanted. And someone else says, no, I know what she wanted. And it needs to be, it's easy if it's just spelled out and clear.
Absolutely. I do have a question here from Guy Parker. He said, what advice would you give to realtors who are trying to partner with probate and divorce lawyers to generate business? And what are some of the things that would set them apart from the average person reaching out?
I have a lot of realtors that I do business with. I don't have a particular, go-to. I do business with you, Nicole. I don't have a go-to realtor, especially in a family law setting. When you represent one side and you want to sell a house in a divorce, I don't think my suggestion, if I'm representing Nicole, or my suggestion if I'm representing, pick a name on here. No, I don't want to pick a name. That's not nice. If I'm representing somebody else, I don't often want to use, say, the person who I'm suggesting, because then that other side immediately thinks that I have something in common with, with Nicole. So I guess just that to answer is get your name out there so that people know who you are, and that, someone like me, I just need to be able to put you on a list of people that I would refer out. Because if someone calls me and says they want to sell a home, I have people in certain regions that I know, North Livermore to Dublin to San Jose, that specialize in those areas. And probate, maybe someone who does probate, 100% probate would be, if you're interested in that kind of work, would be to connect with them. I can give you some off the air. If you send me an email, I can give you some names of people that's all they do. And I know they're always looking for good real estate professionals.
Okay, great. Guy, myself, I guess to speak from my own experience, I've done probate. I've done a significant amount of probate business, and a lot of it really, first and foremost, is really familiarizing yourself with the process and knowing it kind of forward and back, and how that affects sellers if you're dealing with, listings that are going to probate. I kind of learned by trial and error, but you really to know the process so that you can advise the seller that if the attorney they're working with isn't astute, that, you know what, this could be coming up. This could be a potential, and then the timelines as well. Every state's different. California definitely has some different timelines. So just at least familiarizing yourself with the process and being able to speak to it to a high degree is going to be able to win you a little bit more favor, unless you were just to say, hey, I'm a realtor and, I want to do probate. Definitely make it something that you become an expert at. Any areas that I've excelled at in certain markets within real estate is because I've done a ton of research and made myself the expert in that specific niche. So that's just
and I would add to that, Nicole, that one of the things that we see happen a lot is if you don't know what you're doing and you're a real estate professional and you take on a probate case, is be careful, because in the last 6 months, I probably ran into 3 or 4 different situations where a house was listed, a RPA was signed, earnest money deposited, escrow opened, and the seller thought they had authority to sell the property, but they did not. So they did not have probate court permission. The trust, it wasn't writ clearly in the trust. And then you get family members coming out of the woodwork, and now what you've done as a real estate professional is you've sold a house that your client did not have permission to sell, and may not be the real estate professional's fault, but I know you realtors, you avoid lawsuits like the plague, which is smart. And you also have a very good lobby with California Association of Realtors. You guys all have really good E&O policies. So, but that's something that if your client doesn't tell you, or you don't know enough about it, you're not going to ask. When was the last time you asked a client who signed a listing agent with you, hey, do you have the authority to sell this house? That's not a normal conversation. And I'm seeing it a lot. At least in the last 6 months, I've seen a bunch of RPAs that were breached by parties because they did not have the authority to sell. And I'm in litigation on 2 of them right now. And all I'm trying to do is reconnect buyer and seller once seller has the authority to sell, so that there is no lawsuit, because nobody benefits from a lawsuit like that. And frankly, no one benefits from any type of lawsuit right now, since the court system is broken, not even open, and you can't sue anybody right now. So.
Okay. Kelly, you wanted to step in and ask a question?
Yeah, hi. So sorry, I showed up a little bit late, so you may have answered this question. If you did, I apologize. But
if I did, I refuse to answer it again.
Okay, deal. That's
kidding.
fair
I'm
enough.
kidding. I'm kidding.
So for those of us that are dealing with international real estate, how does it work if somebody has foreign property that they own? Can that go into a trust? would you have to, deal with that in the country that it's located? How does that work?
It can be included in the trust.
Mm-hmm.
It can be dealt with in the trust. The issue, same with what I'm dealing with in divorces, is what you do here does not necessarily have any binding authority as to what happens, say, in India. So I have clients who own a bunch of property in India. They get married in India. They move here. They want to get divorced here. They put together this divorce agreement, or they put together an estate plan here. It controls here in California, but if you were to send off, a set of documents to the government in India, are they going to acknowledge it as being binding on them? The likelihood is no. Depending on what country it is and whether or not they're in that UCCJEA, which is the uniform, the Hague. A lot of people will honor laws from different countries, but not always. But I always include everything in the estate plan, because if they're in California laws where it would be probated, California laws where it would be challenged. But if a California or United States court makes an order that such and such happens in India, it doesn't mean that that a court, and I use India because I have a lot of Indian clients, it doesn't mean that the court in India is going to acknowledge it. There's a lot of black money, and underhanded stuff that's going on in India to get certain things done. I'm sure with other countries. So you can do it in both places. I often have do an estate plan here, and then we send it off to their counsel in India to make sure that that's incorporated in something that's in India. But most of the time when they're here, they're staying here, and all they want to do is make sure the property that's back in their homeland is given to the family that's still there.
Awesome. I have a question from Raymond. Raymond is asking, in order to maintain the original tax basis and not the step up California, does a husband/wife need to hold as community property instead of joint tenancy, even if the property is in a trust?
Did they buy it together?
Go ahead and unmute yourself, Raymond, if you want to answer any questions directly.
So holding a tax, like keeping a Prop 13?
Yeah, so they did buy it together, he said.
Yeah, then whether if it gets put into a trust, it doesn't affect the tax basis.
Perfect.
And if it's inherited, then look, if it's inherited by a family member, and the family member is only going to realize the change in the tax basis when they go and sell it, right? So then they're going to get capital gain when they sell it, but the transfer itself is not going to be subject to taxation. That's why you go through I think it's up to 10 million. It might even be increased. I don't have it in front of me, but it might have even been increased to 20 million by Trump, that you're allowed to pass a certain amount of property and assets to your heirs through a trust that are not taxable. But then when you go to sell it, then you're going to have an issue with your explaining your tax basis and the increase in the equity, and the government's going to want a hand in their pocket, in your pocket at some point if you're selling it.
So, and I'm correct me if I butcher this, Raymond. So he also asked, so when selling, if one passes away, so let's just say one of the parties passes away and the surviving spouse wants to sell, what happens in that regard?
It doesn't change the basis. They still have the same tax basis. It doesn't. It's most trusts we write are they're like a pour over trust. So husband and wife are married. Everyone says husband dies first, but I'm going to change the facts and say wife dies first. It pours into husband. Husband now has the complete control of the trust. It doesn't change any of the terms of the trust. Look, at that point, it's still a living trust. It still can be modified. Husband can then change it if he wants to. You can write it in a way that it can't be modified and when it pours over, but I don't recommend that. But it's essentially just losing one member of a trust when it's not going to change the basis.
Okay. Evan, do you have a question?
Oh, was my body language that obvious? Okay. Yeah. So yeah, thanks Nicole for organizing this, and thanks Kent for participating. But so if I've got a schedule of real estate with investment properties and they're vested in LLCs, I could amend the operating agreements for those LLCs. So upon my death, my ownership interest goes to someone, but I'm assuming that would trigger a tax event.
It could, correct.
Okay, so you mentioned transfer on death deed. So I'm wondering, could I arrange a trust so it does not, upon my death, it takes effect immediately and not a minute before that?
Yes.
Okay.
Yes, you can. And what you can do too with those LLCs, you can have trusts own interests in LLCs. So I have a lot of clients who will develop property, and they have, Nicole and I are going to build condominiums on Sand Creek, and we call it Sand Creek LLC. And Nicole owns half of it, and I own half of it. But the half that I own is owned by the Kent Tierney Living Trust. So it is a trust asset within my trust. So my trust can control how that LLC distribution would flow. So if it flows back to me and I own it, I can run it, I can have it be subject to my trust.
Right. So I guess my concern though is the way things are set up now, it's working for me. But obviously, upon my death, I want things to transfer over to my heirs. But I guess that's the key. I'm remiss to make any changes now, but obviously once I'm dead, it's too late.
Well, Howard, if you're true, and if you're, if you have title, a property is titled in certain names, whether it's husband and wife or it's your LLC, you can always do a title transfer that is not subject to reassessment and doesn't trigger any taxation. It's just a simple changing the beneficiary. The trust is now it's now in the name of the trust. It's still a pass-through entity for you, right? So if I own, Evan owns 40-something% of such and such LLC, you can put that into your trust so that your trust is truly the owner of that percentage, because you and the trust are the same. It's a living trust. It's an inter vivos trust. You're the trustee of it as soon as you die, then those shares are subject to how the trust is handled, but it's still owned by you. It's not owned by anything special by creating a trust. The trust just allows your family members to take it without having to probate it, take it without having to deal with a lot of these really screwed up intestate laws. And it makes your partners or your business members in the LLC, they have to deal with you even though you're gone. Now they're dealing with this vehicle that transfers the assets to your family and protects your family. That way, when you're gone, you don't have to worry about how are they going to get the distributions out of that LLC, or how are they going to get their ownership shares out of this. And it all depends on how your LLC operating agreements are written and who wrote the operating agreements. A lot of operating agreements are downloaded from the internet. I have no knock on documents that are available on the internet. A lot of them are great, but if you download something from the internet, you better send it to someone like me and say, hey, can you spend 5 minutes and tell me if this thing is legit? Because we see a lot of contracts in business where one sentence, if you switch the sentence around, you've changed the indemnity from one party to the other. And to the naked eye, to a layperson who's not trained in legalese, I could show you 3 contracts. You could look at all 3 contracts and you could say, oh, those are exactly the same. And I could go back and show you and this is what lawyers do. We get paid to do it, is in that 2-sentence section, they flipped liability around. They've changed the indemnity away from one party and put it all on another party. And you think you're signing a contract that protects you when really you're not. You're signing away. I'm indemnifying them for anything that happens, whether it's my fault or not. That's why I always say, find a lawyer like I'm not even like me, but someone who's like me in that if you sent me an email, I'm not going to nickel and dime you. And I'd spend 10 minutes and look at something for you and say, hey, I wouldn't sign this. You can't just trust your instinct on signing legal documents, especially now that so many different versions are available and people are, not the most honest.
Thanks for the
But
advice.
there's a way to do it, Evan. There's a way to do it, Evan, for sure, where you can protect your who's going to inherit those interests in those LLCs.
That's good to know.
And be really clean.
Yep. And just before I go into the next question, I just want to say myself, Kent really is the attorney that you can go to, and he'll give you an honest opinion without, like he said, nickel and diming. I've worked with him for over 10 years. He protects my assets. He protects me in every possible way. He always has. So he's someone I do trust with every aspect of my business, my personal life, everything. So I'll give his contact information at the end if you guys ever need anybody to.
Yeah, I don't mind. Go ahead. I don't mind at all. And I will say this, so for the people who are on here, I'm not the lawyer to call if you want me to agree with you and tell you what you want to hear. It may be a fault of mine, but I'm not going to sugarcoat stuff. I'm too old now. I've been doing this too long to tell you what you want to hear. Trust me, there's lawyers in my building, down the hall, across the street, next door, that'll tell you what you want to hear. And good luck going with the ones who tell you what you want to hear, because you want a lawyer who's going to be honest with you and tell you the truth, whether it hurts or not.
I can attest to
Kent, you're in California, but you can practice in other states?
No, I'm in California. I can practice in California. However, I have clients that are, say, based here in California that have businesses in Kansas and Missouri and Colorado and Idaho. And hi, Jaden.
This is my reason to protect my assets right here.
And I've been doing this for so long that if you have something in a different state, I can hook you up with somebody in that state and kind of guide you, through what you need here in California versus if you have an LLC in Wyoming or, corporation in Delaware. I know plenty of people that quarterbacking through us will help you, so you know that you're getting to the right person, as opposed to just, hey, call this guy. He's in Idaho. He'll help you.
Yeah, just like realtor referrals, Kent definitely has the same type of network. So, Oneed, you have a question? You want to go ahead and unmute yourself and ask?
Yes, thank you, Nicole. Kent, you knew Nicole speak French. You knew that?
Oh, we speak French?
Yes, Nicole.
I know one word in French.
First, before I go to the question, is California a community state?
Yes.
Oh,
community property.
That means it's like Florida, community state.
Correct.
I have a couple, friends of mine for the past 30 years. I am young, don't worry about that. Okay. And both were married, they lived overseas. They purchased a home. No, I don't say they. The husband, before he purchased a home on his name here in Florida. And they don't have children together. The husband who passed away, he lived 2 children, 1 grandchild, and a daughter also, a daughter and a daughter. And he passed away. The lady, they lived together for 28 years, but overseas. But they come back and forth in here, enjoy their house. And finally, I would like to know if the wife is entitled to anything in that property, or if the house belongs only to the children.
Well, first of all, you're asking me a question about Florida, so I don't know Florida law. But if you're talking about community property in general, that you say they were married.
Yes, they were married for 28 years.
Okay. If you're married and you own, and the property's titled in a certain way, husband, wife, in joint tenancy, then the wife would inherit the entire community estate. The children would get nothing unless there was a specific provision in a trust document or a estate planning document that would leave it to them. So I'll give you an example here in California. My dad had a second wife, and I have a sister through that marriage, and I have a brother from the first marriage. When my dad died, he had a trust, but everything, they owned his home he owned with his wife. And when my dad died, everything in his estate went to his wife. My brother and sister and I didn't get anything because they were married, and it was titled in the married couple's name. Now, my stepmom's a great lady. She's updated her trust and has provided for my brother and sister and I all together, so it's fair. But the kids in that situation, if it's not planned correctly, which goes to, I think, the theme of Nicole's of this entire telephone call or this Zoom conference, is the need for having estate planning in place, so children of that deceased client of yours have some way to get a piece of that estate upon his death, if that's what he wants to happen. Because oftentimes when you don't do that, now wife, not the mother of those kids, now has the home herself and all those assets, and husband's children from a prior marriage, whatever, aren't taken care of. And if that person is not a good person, there's really no obligation to provide, the deceased person's kids with anything. And that, I think that's a fine line. And I don't know how it's titled. I don't know where in Florida. I don't, I'm answering the question in a vacuum, but I can tell you based on community property laws, if it's titled the way it normally would be titled, then she would be entitled to it. If it was in his name and his name only, then the kids would likely inherit that, and then they would be fighting with wife as to who actually gets to keep the property and whether or not they need to kick her off, out of the property. And then that's why you do estate planning, so you don't have to evict your stepmom.
Yeah. Okay. No, the house, the deed is only on the husband's name.
Then it's probably going to go to the kids.
Yeah. Okay. Yeah. That's good. Good to know. Thank you.
All right. Well, we're about to hit an hour here, so I just want to thank everybody for showing up today. I kind of had a feeling that this topic might be somewhat off-putting because just the general premise of it, even just how I know people, they're hesitant to talk about these kind of things. So I'm going to work on seeing if I can get the recording to put out there to the FIABC community in case there was somebody who wants to see it but didn't want to actually engage, because that might be a situation. So I'll see about getting it put out on the FIABC website or the Facebook page. But I want to thank you all for showing up today. If you have any other further questions, I will post Kent's contact information in the FIABC members page.
Feel free to email me. If you think of something later and you have a question, you can email me. I don't mind. Sometimes these questions are hard to talk about out loud with others in the room. So if you have a fact pattern or a specific question, just get in touch with me. I'm happy to answer it.
Perfect. And I just want to thank you, Kent, again for another amazing session. Your session on Monday with Jamie on tenancy was a huge hit. Even people that didn't make it in are asking for the recording. So that's another one I'm hoping to make available to everybody.
My pleasure.
So
My pleasure.
Thank you for your time and your expertise.
No problem. I'm happy to do it.
Awesome. Well, you guys all have a fantastic weekend. Happy Mother's Day to your wives, mothers,
Hey,
everybody.
Nicole, happy Mother's Day.
Thank you. And my birthday's tomorrow.
Oh, happy birthday too. All right.
Happy birthday to
Yeah, you have a good weekend.
Happy birthday.
I will.
Listen to Odie go.
Happy birthday to Nicole. Happy birthday to you.
All right,
Thank
nice. You
you.
saved
That
us
was
all from having to
awesome.
sing it.
That made my day. Thank you, Odie.
Okay,
right.
bye-bye.
Yeah, can you teach,
All right.
Odni, can you teach me to make my voice do that? That's good. You know, that,
Oh, yeah.
that
Oh,
vibrato,
yeah.
that's good.
Especially in French, okay?
Everybody have a good weekend.
Thank
You
you.
too.
Bye.
Bye-bye.
Thanks, Nicole.
Bye.